Good afternoon and welcome to the Public Service Commission of South Carolina. We are here today to conduct interviews regarding a request for proposal for consultants and experts related to the 2022 competitive procurement of renewable energy proceeding to be filed by the South Carolina Public Service Authority, also known as Santee Cooper. This is in docket number 2022-104-E. And we are interviewing prospective consultants who have submitted responses to the RFP. Let's take a roll call of commissioners before we get started. Present in the hearing room, we have Commissioner Justin Williams, Commissioner Thomas, and Chair Belser. And with us virtually, we have Commissioner Irvin, Commissioner Caston, Commissioner Carolee Williams, and Commissioner Powers. And at this time slot, we are conducting the interview with London Economics International LLC. And I understand that we have on WebEx, we have Mr. A.J. Goulding and Ms. Marie Fagan. Is that correct? I see Mr. Goulding.
Yes, that's correct.
Good afternoon. Thank you for being with us today. First for responding to the RFP and then for being present today to respond to questions. Before we jump into things, do you have any questions of us at the moment?
No.
Okay. Well then, Mr. Goulding, we will turn it over to you and Ms. Fagan to make your presentation.
Great. First of all, thank you so much for the opportunity to interact with all of you again today. London Economics International is a U.S. owned and operated firm that specializes in energy and infrastructure, particularly regulatory economics and asset evaluation in the electric power space. We have prior experience in South Carolina and in the U.S. Southeast, as well as significant prior experience in designing procurement initiatives, as well as serving as either an independent evaluator or as a fairness advisor in those types of processes. My colleague, Dr. Marie Fagan, is very experienced in serving in these roles, as am I and other members of our team. We'd be obviously happy to take your questions.
In response to the hearing officer directive and order that went out last week, did y'all prepare a presentation or prepare written responses to the questions?
Yes, we have prepared written responses to the questions.
Okay. Do you want to lead us through those? You don't have to read the question. If you can frame it, your responses by the questions.
Yes, and do you want us to go through both what I might call the administrative questions and the functional experience questions? I'm happy to go directly through the table of questions with Dr. Fagan's help. What works best for you and the commission?
I think that works fine. We'll go through the administrative things first. I know we've heard from y'all before. We have an additional party here that I think we did hear from you before on that. But just so that we have a complete record and complete interview, let's go through those and then into the functional questions, please.
Okay. We have appeared before the Public Service Commission of South Carolina as an independent consultant, and that was in docket numbers 2021-88-E, 2021-89-E, and 2021-90-E. With regards to the 2021 avoided cost proceedings. And we have also been engaged to assist the commission in the upcoming 2023 avoided cost proceedings. Um, so if we go on to question 2, we have not been employed or retained as a consultant for the South Carolina Public Service Authority at any time. Question 3, um, uh, to the best of our knowledge, none of our employees, associates, contractors, or partners have ever been retained to represent IOUs in South Carolina. We've noted in our response that LEI in April 2020 was engaged by the Public Utilities Commission of Ohio on matters related to Duke Energy Ohio. And that because of the way that the process works there, the payment comes directly from the utility. That was an audit of the price stabilization rider. In 1998 through to about 2000, LEI was engaged by the Dominion Energy subsidiary Virginia Power on a variety of matters. Moving to question 4, none to the best of our knowledge, none of the members of our immediate families, partners, or associates own Santee Cooper bonds. For question 5, we have no reason to believe that we cannot serve as a fair, impartial, or independent consultant for this docket. With regards to ongoing business dealings for question 6, the firm currently has no interest, direct or indirect, which would conflict with the performance of services under this contract, and shall not employ in the performance of this contract any person having such a conflict. Question 7, no, we are not currently engaged in any negotiations to represent any of the parties before the Public Service Commission, nor do I believe we're in negotiations with anybody to represent them before any other Public Service Commission. With regards to licenses, degrees, and designations, I am an adjunct associate professor at Columbia University's School of International Public Affairs, where I teach a course in electricity markets. Dr. Fagan has a PhD and several decades of relevant experience. With regards to utility-related trade groups or organizations, LEI is a member of the Northeast Energy and Commerce Association, the Association of Power Producers of Ontario, Independent Power Producers Society of Alberta, and participates from time to time in the Gulf Coast Power Association. LEI also participates in the Energy Bar Association. With regards to question 10, yes, LEI can provide final written proof of conflicts check from the firm. Question 11, if we are hired as a consultant, we are willing to abstain from any unauthorized ex parte contact with current or future parties in this docket. With regards to question 12, we are not aware of any reason that the firm should not serve as an independent expert in this docket. Question 13, the schedule for project completion is dependent on the timing of the proceeding. Our understanding is that Santee Cooper is expected to file its 2022 CPRE filing on November 1st, 2022. And that a procedural schedule will be issued thereafter. And LEI's work schedule, work plan will, LEI will work to reflect the procedural schedule when it is issued. Question 14, which is estimated hours per task and estimated total labor hours. The estimated total hours are in the range of 370 to 450 total labor hours, consistent with the desired scope. Those are divided by task. For task 1, the review of the filing and of any supporting documentation, we have approximately 60 hours. For task 2, to prepare and issue interrogatories and requests for document production, approximately 30 hours. For task 3, to perform independent analysis and review, we're looking at somewhere between 125 and 200 hours. Preparation of the written report would be 80 to 120 hours. Oral testimony, if needed, is dependent upon the schedule and requirements, but also needs to include some estimate of prep time. Thus, we have looked at something in the range of 50 to 70 hours as providing a reasonable estimate. The estimated total costs, here I'd have a question. We'd like to submit these as confidential, but we just want to make sure that that's consistent with your current procedure.
Mr. Goulding, we will be asking for any submittals to be sent to Mr. Hall at the procurement office, not directly to us, and then he will mark those as confidential as needed and send those to us.
Wonderful. Thank you so much. With your permission, we will address question 15 in writing through that procedure. Now, moving to question 16, relative to the requirements of the code, what information does the commission need to receive from us? In reviewing the code, what we see is that Santee Cooper is required to procure renewable resources that through a competitive solicitation process open to all independent market participants that meet minimum eligibility requirements. Santee Cooper needs to issue public notification of the intent to issue a competitive renewable solicitation. And just to be clear, the reason that I'm listing all of these off is because it would be the job of the consultant to assure that this has happened in a reasonable fashion. There's a requirement that the eligible participants have a valid interconnection request on file and use renewable energy resources. Prior to each solicitation, 45 days, A pro forma contract is necessary, a bid evaluation methodology that ensures all bids are treated equitably, and interconnection requirements and study methodology. Winning bids need to be based upon a published evaluation methodology, and the results need to be submitted based on using a public report that provides a summary of submitted bids and an anonymized list of project awards. So this list guides the activities of any consultant reviewing the process. Not just from a timing perspective, but critically that you have an understanding of what competition means. So there needs to be a clear definition of what the minimum criteria are for a competitive process, how many bids need to be considered, can one participant win all of the available capacity? We need to have an understanding, and the consultant will need to be clear on how they're going to determine that the process was actually competitive. Likewise, in terms of the initial publication of the RFP, did the utility do a reasonable job of publicizing, or do they have a reasonable plan for publicizing the RFP through the public notification? So we believe that all of these things are going to frame what the consultant says, in addition to providing more detail on the evaluative methodology whereby winning bids will be accepted. Moving to question 17, our firm does not contribute to political action committees. There in question 18 is no one who currently works for our organization who has worked for a public utility or for Santee Cooper in the past, nor has anyone in the past, nor does anyone in the past currently work for Santee Cooper. There are folks in our organization in the past who currently work for public utilities in the Northeast and in Florida, though I should clarify that in some cases they work for the competitive affiliate, not for the public utility themselves. So if we take present employees, there is no one who is currently employed by the firm who has any association with a public utility company or with Santee Cooper. So that's question 20. Moving on to subject matter questions. Yes, we have consulted with a number of parties with regards to competitive procurement of renewable energy program. These qualifications are described on page 14 to 18, but Marie and I will also just give you a bit of background. Marie, do you want to mention some of the competitive procurements that you've worked on?
Certainly, thanks, and thank you, commissioners. So very recently, we worked on a competitive procurement for integrated utility in the U.S. Northwest for their solar RFP. And so there were some interesting experiences there because it's solar, and rather than say more complex projects like gas, for example, when you have a renewable RFP such as that, you have quite a few bids, quite a few bidders. The bar is usually lowered technically for folks to bid on these. So some of the takeaways, the best practices, the things that we learned had to do with making sure the minimum requirements were sufficient and enumerated very carefully. There was kind of a long list, but it really helped to be able to make sure that bids were viable. But we worked on that project kind of from soup to nuts. We helped review, how the RFP was written. We reviewed the publication of it, how many, folks received it, were able to submit bids, looked at in parallel to the utility, we did our own independent scoring of the various bids, comparing that to the utility scoring. And we also monitored all the interactions with between the utility and the bidders to make sure everybody's treated fair and equitably. So that's one, that's one very recent example. We've worked on a number of renewables related RFPs.
Yeah, and just to augment what Dr. Fagan has said, I have also served or oversaw the firm's work as the fairness advisor for procurements by the former Ontario Power Authority, which is now part of the Independent Electricity System Operator in Ontario. The firm conducted similar procurement oversight functions in the state of Connecticut. And I have also served as the procurement design expert for a large-scale renewables program overseas. Now, Marie, in terms of the size of the competitive procurements that you've been involved with, can you give a range?
Not offhand. I think it was about a 500 megawatt.
We'll cover that in the written responses.
We've got some more detail. Yeah, I'm sorry. Yeah.
So the competitive procurements I've been involved with have ranged from 3,000 up to a multi-year procurement design that was intended to procure over 20,000 megawatts over a 10-year period. Question 28, experience drafting data requests or discovery. Yes, we have significant experience doing that on behalf of both regulators and regulated entities across the US and Canada. One example for a recent engagement with a regulator in the Southeast, LEI conducted audit and management review, and this included formal written data requests over a 5-month period, issuing 197 DRs to the utility on topics such as organization, staffing and controls, general fuel procurement, plant operations, environmental commodities, fleet operations and trading. Now, I should add that the number of DRs is going to vary depending on the proceeding. And we don't view our role as just creating questions for the sake of demonstrating our existence. The questions that we do come up with are those that we feel are necessary to fill a gap in the record. And so in some proceedings, we may end up with 15 or 20. In other proceedings, you may end up with many more. But we are conscious of both effectiveness and efficiency in terms of how we address the need for DRs. For question 29, the team members include Dr. Fagan is project lead. Myself, another senior member of my firm that has more than 20 years of experience, along with support from a team of analysts. We would expect to have between 5 and 6 people on this particular task. Most of them located in Boston, Massachusetts. Their backgrounds include economics, finance, and all have experience in regulatory economics matters. And so if we think about the work that we propose to do, if we go back to the tasks, there's the review of the filing and any supporting documentation. That is done always thoughtfully. And anytime you review a filing like this, you need to go in with an understanding of the status quo and the way in which that filing fits within the broader context of state policy. And so when we talk about performing that task one, it's not simply about reading the filing, but also making sure that we have read and reviewed other relevant documentation that is needed. Preparing and issuing interrogatories and requests for production of documents. Our focus is often on things like showing math, understanding the basis for assumptions. We will generally look for assumptions for which there hasn't been evidence submitted, or for which the evidence seems to be in need of additional documentation. So the interrogatories and requests for production are about looking for holes and crafting questions that are not intended as gotcha questions, but are really intended to fill out the record. And this is all part of the independent analysis and review as well, in that we will be effectively benchmarking the CPRE against what we think are best fit and best practice approaches to the challenge. And we'll talk a little bit more about that in future questions. The written report will describe the filing, describe the status quo, describe a set of best practice, best fit approaches, evaluate how the CPRE filing is or is not consistent with those practices, and create recommendations that will address any particular gaps. We do emphasize that looking at best practices is not a matter of cutting out a few pages from a manual, putting them up and saying that these apply universally. Each state is different. Each individual utility and its service territory are different. And it's important to make sure when thinking about whether a proposal is consistent with best practices, the local context. Moving to question 30 about the issues that can be expected during the administration of the competitive procurement. Marie, do you want to start on that, and then I'll augment?
Sure, sure. So with competitive procurement of renewables, particularly, as I mentioned previously, very often the procurement will end up with quite a few bids. So just so one of the expectations is that sometimes the process will take longer, sort of per megawatt that's being sought after, just because the sort of administrative burden of working through many hundreds of documents, um, obviously and it's important to look at all of the qualifying bids in order to have a fair and equitable process. So that's one piece of it. Just expecting that you might get quite a few in a renewable RFP and the time that it takes to go through those. And when LEI's done this in the past, we have an organized and efficient format of looking through all the materials that we need to review. And then sometimes you would also see a wide sort of quality in the offers. Some bidders are extremely creditworthy, some bidders perhaps less so. So it's obviously important to have the credit materials in place, um, perhaps security, depending on some of the bidders. Um, and then, you know, worst case scenario aspects of contracts, like perhaps force majeure clauses. And again, just all of that is important, but it becomes even more important when you're dealing with a large number of bids and bidders.
Yeah, so I think that the message is in renewable procurements in particular.
Mr. Goulding, you're really hard to hear right now. I don't know what happened.
Um,
That's,
uh,
that's
is
better.
this any better?
Yes, sir. Thank you.
Awesome. All right, my apologies. Um, uh, so with regards to competitive procurement of renewables, um, it's important to have procedures in place whereby you anticipate that there's going to be a large number of potential bidders, that your criteria are clear with regards to selection, and you may need to set some gating criteria, some minimum requirements that if bidders do not meet these, they do not get scored at all. So um, this is a sample of the issues that may arise, but we think these are among the most important. Question 31 asks about caps or limitations for the procurement. And it's important to give bidders guide rails with regards to the minimum and maximum size of projects that would be accepted. Also important to be clear about the total amount that's being procured. In addition to caps and limitations, typically you would look for criteria that demonstrate the ability to meet the target commercial online date. You need to think about where you want people to be in the interconnection process. And as noted, there are some criteria from the law there. Evidence of some form of site control and credit information. So the caps and limitations would not only be on the size of the project and potential output, but also on the characteristics of the bidder. Question 32 asks if we have ever participated in or acted as an independent administrator for competitive procurement of renewable energy program, and the answer is yes. and we have details in the quals, but I previously mentioned the example of the process in Connecticut that we ran. And that's an example of serving as the independent administrator. Moving to question 33, the type of guidelines or best practices. Marie, perhaps you can elucidate on this.
Okay, sure. The guidelines and best practices obviously begin at the very beginning, at when you're obviously developing the RFP document, and also deciding how to disseminate the document. We always would recommend disseminating to as wide a field as is possible, because obviously a wider field will get you more bids, and more bids is more competition, and a better, better opportunity for lower costs to the consumers. But given that, you want minimum eligibility requirements, some of which are enumerated in the law, but there's longer lists of those that can be examined to find which apply to your specific situation. The timeline as well. The bidders need enough time to prepare viable offers and credible bids and be able to put their documentation together. The weighting and scoring should be set out ahead of time and also be transparent for the bidders and also the folks who have to evaluate the bids. We've seen different jurisdictions use strictly cost-based criteria. We've seen jurisdictions use non-cost criteria as well. If there are non-cost factors, then there needs to be a clear weighting and scoring methodology that's, again, transparent from the beginning of the process and apparent to all bidders. We've seen a number of different approaches to scoring and the benefits and costs. Some of them will score what we call impact, maybe the largest net benefit. Some of them will score sort of the efficiency, the benefit per cost. So you can look at impact and efficiency in scoring the bids, but either way, there's methodologies to put that in place again ahead of time, so that everyone in the process knows what's coming. If and again, you get a variety of bids. Some may offer a fixed price, some may offer prices escalated over time. You'll need to have a process in place to figure out what discount rate to use, et cetera, just to put bids on an equal footing. So those are some of the things to think about. And again, given a specific situation, there's more as well.
Thanks, Marie. Question 34, a weighted decision matrix and whether that's something that we recommend. If you're going to consider non-price factors, then it's going to be essential to have some form of weighted decision matrix. And as Marie pointed out, we've seen jurisdictions use both, but a transparent weighting and scoring methodology is the best way of incorporating non-price factors. Now, there's the question about technology neutrality is one that can be incorporated by being clear about the specifications of the power that you are procuring. Are you looking for it to be firm, which means that intermittent resources would need to demonstrate some way of either through battery storage or other processes to include that in the bid? Or are you going to allow a more diverse set of bids, in which case your net present value scores need to really determine how to account for the difference in the value proposition between firm and non-firm submissions? Question 35, do we have experience in state-regulated energy markets such as South Carolina? The answer is yes. In addition to working in South Carolina, we've worked across the South in Mississippi, Louisiana, Georgia, in other state-regulated energy markets. We're currently working in North Dakota and have worked in Vermont in the past. Vermont is the only state in New England which does not have competitive electricity markets, although it's a part of ISO New England. The list of best practices for competitive procurement of renewable energy. I think, Marie, you'd identified 9 best practices. Maybe you can share them here.
Okay, sure. And as AJ mentioned previously, everything's in context. So what constitutes a best practice in one situation may not be the same as in another, but it gives you a framework to begin with when we look at these. So first of all, again, starting from the beginning, the RFP needs to comply with all the procedural requirements, any commission orders, et cetera, should be sent to the widest range of bidders. And these are some things we mentioned before, but the evaluation criteria and modeling assumptions need to be clearly specified and without biases. And then fourth, if there are any change to these modeling assumptions, they need to be justified based on factors that are external to the RFP. And fifth, the evaluation criteria and the analyses of the bids have to be applied correctly and in a blind process. And sixth, all communications with bidders must be made public. And seventh, when you're at the stage of contract negotiations, even though contract negotiations sometimes adjust terms, they shouldn't move terms very far from what the pro forma documents, which are part of the RFP, illustrate. And eighth, if there is a utility-owned generation participation in the RFP, a self-build participation, we feel that heightened monitoring is generally required. And finally, when you think about the folks evaluating the bids, they need to be trained similarly. They need to be given similar checkpoints so that you can have a fair comparison across the bids. And actually what we found is that any given factor should be examined across all the bids by the same evaluator. So rather than sharing the project sort of bid by bid amongst evaluators, it's a lot more consistent to give each evaluator a specific factor to look at across all the bids. So again, these are general guidelines, and obviously how they're applied has a context. We also have checklists for evaluating best practices for PPA contracts versus turnkey contracting. I won't go into a lot of detail here, but there's various offers that you might get where you want to actually check these the types of contracting best practices.
Dr. Fagan,
Thanks, Marie.
may I ask a question? May I ask a question of Dr. Fagan? Dr. Fagan, when you were just talking about evaluators, the same evaluator across the bids, are you saying that there would be one evaluator for all bids, or there might be multiple evaluators, but each evaluator takes a segment to evaluate that segment across all bids.
Yes, that's correct. The second,
Okay.
where you may have a team of evaluators, but say one person looks at creditworthiness across all the bids, for example.
Okay, thank you very much.
Question 37. Do you believe that Santee Cooper can act independently in organizing, managing, and evaluating a competitive procurement of renewable energy? So I think the main question is whether they are also participating. I think it's very, very difficult to run a competitive process in which you or an affiliate are also involved. So now, even if Santee Cooper is capable of doing this, having some independent party involved helps to add credibility to the process. And the question is usually not whether the people at a utility are good at their jobs, but running such a procurement is not really a daily ongoing activity. And so what you tend to find is that when utilities try to do this themselves, you end up with people that are potentially overburdened because they continue to have their ongoing day-to-day responsibilities, and it can result in slower processes. So it's certainly not impossible for an entity like Santee Cooper to run an effective process, but there are challenges. So question 38 asks about what particular model should be used to understand the interaction with existing resources of a utility and the interaction across different portfolios of bids. And we've seen across jurisdictions and utilities a number of different models that have been used. Generally, they are production cost models that estimate the impact on energy prices, or depending on the market design, other attributes, capacity, ancillary services, and so forth. But the most important element is that the model properly reflect the features of the energy system that will be impacted by the new resources, and that it reflect some reasonable assumptions about future evolution. That is, it not be based too much on historical relationships, because these will change as the portfolios are added to the system. Question 39, how do you incorporate factors such as resilience, equity, and economic development into a competitive procurement of renewable energy process? And so I think the answer is, first of all, you need to be careful about muddying your objective function. So the more things that you're trying to accomplish with a procurement, the less likely it is that you're going to do any one of those individual things well. And so if you move away from using least cost as a metric, you are effectively accepting that you're willing to pay a little more for projects that have specific attributes. And at the margin, that may not change the outcome much, but you also risk incorporating a number of more subjective measures into the procurement. So some of the things that we have seen have been processes that provide for certain allowed adders to bids if they meet particular criteria with regards to resilience, equity, or economic development. We have seen sort of two-stage procurements that start with a ranking on price, and then go back and rank some of these other activities. We have certainly seen and recommend guidance with regards to locations on the transmission system. And it may well be, depending upon the jurisdiction, that there are certain kind of communities that are deemed to be overburdened by energy infrastructure, and you may decide in your procurement to say that we won't accept projects that are in this particular area. So the factors can be incorporated. They can be incorporated through scoring, or they can be incorporated by identifying particular areas or regions that would receive preference. But any such process needs to be cognizant of the cost and efficiency trade-offs. It may well be that these objectives are better, more efficiently met by measures and policies that are outside of the procurement. Question 40, the appropriate time for a competitive procurement to take place. First of all, you need to be realistic about the development process. And so you're generally looking 2 to 3 years in advance of when the need would arise on the system. And Marie, you had some other good points with regards to incentives, if you can elaborate a bit.
Sure. So we know that renewable energy, various kinds of renewable energy are eligible for tax credits. Sometimes those come and go. So the timing of sort of legislation or what's on the tax books and when it might expire is an important consideration. And it's something just to keep track of, something that we follow. So you want to take into account current or expected tax changes or subsidies. And apart from that, solar and wind resources, a lot of the infrastructure or the equipment for that is built overseas. In the past, some of it's been subject to various tariffs or other sorts of regulations on equipment. So that's, again, something to be considered. Things might be in short supply, immediately, but the market may expect to be, better supplied in a couple of years. Again, just a level of market awareness is important. And then finally, actually, no, I think those are probably the two main things to think about, because renewables tend to be capital intensive relative to the cost of energy. So you want to make sure you're timing so as not to hit a period of very high capital costs, which the taxes and any kind of regulations could affect.
Yeah, I think one additional point is if there are major reinforcements scheduled for the transmission system, it is good to take those into account with regards to the timing of the procurement. So question 41, what is the role of a distributed energy resource program in competitive procurement of renewable energy? And can these two programs exist in balance? And there's a couple of ways to approach this. First, in designing the procurement, it will be important when setting minimum thresholds, if you choose to set minimum thresholds, to also determine whether bidders will be allowed to aggregate resources that are under that threshold. So we can imagine a procurement that would allow for, let's say, aggregation of a bunch of residential rooftops, provided that aggregation came up to whatever the minimum threshold was in the program. Um, uh, or we can imagine something that says aggregation is not allowed. All of those projects, the sole avenue for participation is through a DER specific program. Now, if the two programs are completely separate, then there needs to be a clear understanding of the quantities that are expected to be procured through the DER program, because that's going to affect the size of the procurements on the competitive renewable energy side. So, yes, these programs can exist in balance. There are always going to be some uncertainties surrounding these. Best practice for DER programs will put some kind of an upper bound on what's going to be procured, so that there's an understanding of the system impact. And that upper bound in turn will help in terms of planning for the size of the competitive energy procurement. Question 42. What are the characteristics of generation that is encouraged under a competitive procurement of renewable energy program? And I think we can think about this through two different lenses. First, it has to meet the criteria of renewable that's set out in the code. And so the code lists solar PV and thermal resources, wind, low impact hydro, geothermal, tidal and wave energy resources, recycling, hydrogen fuel derived from renewable resources, combined heat and power, biomass, and battery storage charged exclusively by renewable energy. And so those characteristics, if you have something that's not in those categories, you're really not going to be able to include it in the program. But secondly, you're going to be most interested in those resources that have profiles that are peak coincident. And this gets back to the challenges of designing the program, and whether you're going to be technology neutral or whether you're going to have different tranches, either that are technology based or load shape based, that you would use. But the characteristics that you want are peak coincident or load following, but many intermittent resources are clearly going to be challenged to provide these things. And so your procurement may either add bonuses to bids from folks that have these additional characteristics, or you might procure them in a separate tranche. Moving to question 43. Consultant will need to read pleadings, discovery, and pre-filed testimony, describe and discuss experience with similar situations. I think we demonstrated in the avoided cost proceedings that we have those skills, and we have similarly had to monitor processes and proceedings in many U.S. states and provinces. So we have a process in place, and it includes monitoring the docket, includes being on and observing proceedings, and particularly being able not just to observe, but also to identify what's important and the way in which it impacts our work. And so this is not a mechanistic process for us. Question 44, approach and experience with regards to listening to testimony, and providing a clear written report, including an executive summary. I won't repeat some of the things I've said elsewhere, but I will say that providing a clear written report is our overarching objective with any client. We usually design a document to be read in 3 layers. There's an intro paragraph for the person that has less than 5 minutes. There's an executive summary for somebody that has 10 minutes. And those are backed up by a detailed report that is organized in a way that you can clearly find what you're looking for. So we put a great deal of effort in making sure that we are intelligible because we understand that the audience has their own areas of expertise, which may not be the power sector. So question 45, is the team equipped to undertake this work given the schedule? Based on what we believe the schedule will be, and I just want to be careful about that, but we do believe that the schedule will be consistent with the amount of work required. The benefits of awarding the contract to our firm include that we have experience across the Southeast, that we have significant modeling capabilities that help to demonstrate independently the way in which we come to certain calculations and conclusions. We have a process in place for producing thoughtful and readable deliverables. We have direct experience in similar work, and we are careful to make sure that we are not advocates for any particular resource, that we look at each engagement with fresh eyes and no preconceived notions. Question 46, our experience responding to discovery, being deposed, being cross-examined, and testifying. I have been recognized as an expert in regulatory proceedings in South Carolina, in U.S. Federal District Court, in the provinces of Nova Scotia, Ontario, Manitoba, and Alberta. Marie, do you want to list off the places where you have provided expert testimony?
Yes, AJ. So Louisiana, Mississippi, Ohio, Maine, Massachusetts, and Minnesota.
Question 47. The PSC is in the process of hiring a consultant to analyze and provide recommendations on the IRP. Discuss why it may be advantageous to hire the same or a different consultant. And I think that you can get a good outcome either way. However, there are not significant economies of scale by doing the two things together. The topics are related but different. The procurement obviously needs to be consistent with the IRP, but the practice of running an RFP is a distinct topic. So the benefits of having two separate consultants is that you get a different perspective, and you get a team that is focused on the mechanics and best practices for procurement specifically. But likewise, if you go with the same team, you may have some the ability to demonstrate consistency with the IRP is clearly met, but I don't think that that's a terribly difficult thing for someone that hasn't done the IRP to demonstrate as well. So methodology and modeling. Can the prospective consultant review the competitive procurement and render an opinion on whether the work was performed correctly? Yes, we can, and we have done this in the past in other jurisdictions. 49, how would the prospective consultant conduct the analysis of Santee Cooper's competitive procurement of renewable energy program, financial modeling, technical analysis, et cetera? First of all, we would make sure that the requirements were consistent with the scope. In terms of the quantitative analysis, there are a number of areas that we would look at, not all of them modeling related. So this includes reviewing and reporting on whether the outreach to potential participants was adequate, and whether the solicitation was robust in terms of soliciting a sufficient number of bidders. To the extent that we're able identify whether any participant received information that provided an unfair advantage, or failed to receive information through no fault of their own. Review and replicate the evaluation methodology, and this is important given that both financial and production cost models are used. We would carefully examine the assumptions under both sets of models, determine the reasonableness of those assumptions, and determine whether there is an alternative result that would arise using different assumptions if they're warranted. And it's important to note that at this stage, the consultant may be constrained by what was announced in the RFP. So the review has to take into account what the actual RFP said. Marie, you've also talked about looking at the rankings of bids and comparing it with a simplified set of criteria. Do you want to talk about that a little bit more?
Sure. So depending on the assignment, whether we're running a procurement or we're sort of an independent evaluator, that really defines our role in terms of the quantitative analysis. So, sometimes we'll review models, as AJ mentioned, looking at the assumptions. Are they reflective of, what we see in the energy world, et cetera? So where we may not be, where our scope of work, say, doesn't include running a detailed model, we'll start with an independent ranking of the bids based on a sort of a simplified criteria, which might just be the cost, the price that's being offered on the bid, and rank on that simplified set independently, and then compare that set to what the RFP result came up with, where they have looked at many criteria. And very often the rankings are substantially the same, but it'll give you a red flag for what to look at if there's a few that come out that are quite different. So when we see something like that, we would go back and say, talk to the RFP administrator or our client and say, hey, here's where these don't match. What was outstanding, what was considered in addition to price. So it's just a very efficient way to work. And in our final reports, we would note where things like that came up and how they were resolved.
Thanks, Marie. So, in addition to any quantitative modeling consistent with scope with regards to replicating Santee Cooper's scoring, we would review and report on whether the evaluation methodology was fairly administered and implemented, and then consistent with our role, and prepare a report and be available for cross-examination. I believe this addresses all of the questions that we were asked in the communication. Are there other questions, things that we need to clarify, any way that we can be helpful?
Mr. Goulding, thank you. I think you did comprehensively address the questions that were in the list, but let me ask commissioners. Commissioners, are there questions or any clarification requested of Mr. Goulding? Okay. As I said, I think you were very comprehensive in your discussion, and we certainly appreciate that. Mr. Goulding, I do have a couple of dates for you. I think hearing officer directive that was issued from the procurement officer, procurement director Matthew Hall last week addressed the written responses, and I think you indicated or Dr. Fagan indicated today that there were written responses. Can you file those via email with procurement director Matthew Hall at the Department of Administration no later than tomorrow, Tuesday, September 20th by 3 p.m.?
Yes.
It just it supplements the RFP that you submitted. And then finally, the schedule that was approved by the commission, and you may have seen this directive on the docket management system, which I know you're familiar with, that the final conflict check letter is due Thursday, September 20th, no later than 3 p.m. And I would ask, you indicated about the pricing in hours to be provided as well. If you could provide that with the conflict check letter no later than 3 p.m. on Thursday, September 22nd. Both of those need to go to, all communications need to go through Director Hall with the procurement office, and whatever you need to mark confidential, please mark it confidential, and then he will transmit it to us. Any questions about those instructions?
No, thank you. That's very clear.
Okay. Well, thank
Madam
you.
Chair?
I'm not sure who's speaking. Commissioner? Which commissioner? Commissioner Caston?
Commissioner Caston.
Thank you.
I thought I may have misunderstood you, but I thought I understood you to say Thursday, September 20th at 3 p.m.
I did.
Thursday.
I did, but I think I corrected it to clarify Thursday, September 22nd, no later than 3 p.m.
I wanted to make sure I had it. Thank you.
Thank you, sir. Well, thank you, Mr. Goulding and Dr. Fagan, for participating and giving us a wonderful overview today and responses to our written questions. Thank you for the RFP submitted as well. And we look forward to further evaluating and discussing your proposal. But thank you very much and good afternoon. And if you have nothing else to ask us, is there anything from y'all? That's Southern, in case you're not familiar with that.
We're
So-
learning.
But thank you, and we'll close this interview, and we certainly appreciate you submitting the RFP and responding to our questions today. Thank you. This interview will now be closed.